The next slide that we have kind of illustrates how this whole process works with this trust document. We set the document up, and we're going to funnel all the assets through that trust agreement when the individual dies, rather than going through their own name. And as soon as they no longer exist, as soon as that name no longer exists, then the asset has to be retitled by a court process. So we change all the titles to the name of the living trust, so when the individual dies, now it transfers, and we don't have to go through the probate process. A couple problems with the probate process we point out in the living trust segment is that you have attorney fees that'll run in around 6%. Some places they're capped, but they're usually going to run anywhere from 3 to 8% of the estate. Second of all, it's all exposed to court and to public record. It takes time. It's all contestable by individuals who don't necessarily agree with the estate holder's contentions. With their intentions, they want to contest those intentions of the estate holder. So all that process is available in the court, and then it takes a while. It can take anywhere from 2 years. There are a few record cases where it's taken decades to get large estates with complicated assets through the process. If we leave it in trust, it avoids all that and doesn't go through any of that. So to summarize here, we set a trust up. The owner and their spouse are their own trustees. They don't have to involve professionals or banks or anybody else as necessarily their trustees. They can use them for trust administration and assistance, but they can run the estate themselves. The document's fully revocable and changeable during their lifetime. There's no outside reporting during their lifetime. Nobody has to even know this document exists. In fact, it's greatly guarded and confidential. If you paid any attention at all to the administration of Michael Jackson's estate, they had the will available, but you'll notice a lot of TV commentary saying we'll never know what the actual distribution is because it went through his trust, and that's never going to be made private. When we set the trust up, we have to retitle the assets in the name of the trust for the trust to control and to provide us these benefits. But in the meantime, if John Doe has his assets titled in the John Doe Trust by John Doe trustee, he can buy and sell his assets during his lifetime the way he always did. He can buy and sell an auto titled in the John Doe Trust. He can buy and sell real estate in the John Doe Trust. He can do all these things like he has always done if it were titled in his own name. When he dies, the trust becomes irrevocable. Then the terms that he has set, the conditions he has set, become irrevocable. Only the settlor has the power to revoke those terms, and when the settlor dies, the power of revocation is lost. It's a personal power to the settlor. The same thing with incapacity when they lose the presence of mind. So if we now take our sample estate case and we run it through living trusts, what we would do is we'd split the assets on a really, really large estate. This estate's well over the $3.5 million unified credit amount. It's $8.75 million. We would probably set one trust up for the wife and one trust up for the husband. That would shelter $3.5 million through the wife's trust and $3.5 million through the husband's trust. Now, the key to that is that these trusts are drafted so that when the first estate holder dies between the husband and the wife, their assets don't automatically go to the survivor. We're trying to keep these in two separate piles because we don't want the piles to come together on the survivor's final estate tax return. That's what creates the tax. So that means that we're going to be able to shelter close to $7 million out of this estate if we just divide it between the two trusts. And then what we will do is make the survivor a trustee or co-trustee on the decedent's trust. They certainly are going to be an income beneficiary, and in fact, we can put the power in a trustee other than that surviving spouse to have discretion to use pieces of principal for that surviving spouse's needs to supplement their needs if they would have such a need. The only thing the Internal Revenue Code requires is that the spouse themselves doesn't have the discretion or that pile is taxed to that surviving spouse on their final tax return. So with some minor deviation in the drafting of the provisions, we can have principal available to supplement the spouse if she needs it. We have all the income available to the spouse, and the spouse can be involved in the control of the assets. In our flow chart, we show that we then will take the estate and we're going to divide it into if the two halves of this estate are over the unified credit amount, we're going to divide that estate, and we'll make the portion equal in property to the unified credit amount in what's called a family trust, and then the excess is called a marital trust and can be held in trust, made available to the spouse, but the taxation is put off until the spouse passes away. And in our chart here, you see we still have a red box. We still have about $2.8 million worth of federal estate taxes in this scenario, and so we still have some shrinkage here, and we can improve on this. But we've eliminated that probate expense. You'll notice that we've reduced those items down to zero. In the next slide, we do this same process of a living trust for the son and the son's spouse. And in this scenario now, we can set these assets up in a trust for the wife, in a trust for the husband. We use two trusts in this case, not because of the size of the estate, but because they have separate heirs. They have separate needs. And we can take the son's ownership in the family business, hold it in trust, and if we need to make other family members co-trustees or people knowledgeable in the management of the business as co-trustees, and direct that the trustees use the income from that to support the son's surviving spouse. So this is a way to avoid losing business interests or any other particular need where we want the assets to go down the family tree, not to go to the spouse's children, and we need to put protections in there for businesses or whatever. We can put it in the husband's trust and isolate those assets. The wife can have her own assets and allow those to go to her heirs and her children. So there's a way to have two different sets of intentions, one for the husband and one for the wife, and for that reason have two trusts and allow that to meet both intentions and allow the assets to flow down to these heirs without tax complication. You'll notice on this chart, the box normally that would have been in red with a lot of estate taxes is now gray because we've eliminated the taxes and we're done with this particular smaller estate just by implementing these living trusts.